Hello, welcome to Defense Diaries. I'm your host, Bob Mata, and today is Wednesday. I think it's the 3rd of September, if I'm correct. Maybe the 4th. I don't know. They all blend in. The 4th. It's the 4th. So had a nice break. I was with y'all for a hot minute yesterday. There's just a ton going on. In the true crime world. And I'm trying to keep up with it all. I'm kind of glad that this week was not a trial week because it gives me the time to backtrack and get to some stuff that I've fallen behind on. Right when I was getting ready to do Delphi, the Syed thing dropped from the Maryland Supreme Court. And that has been a case that I've been following, especially the procedural posture recently. So after the post-conviction stuff, and when we got to the point where the state had filed a motion to vacate the conviction, I really started to dig in because that's the kind of stuff that I love. I haven't been so much involved with all the bickering back and forth about Syed'S innocence or guilt. I've been more interested in what's going on here because I wasn't there. I wasn't there when Hae Min Lee was killed, so I don't know. And I'm certainly not going to sit here and act like I know. That's just not my style. It's not what I do. But what I want to do today, what I really want to get into with y'all is this epically long, thorough opinion by the Maryland Supreme Court, wherein the bottom line, as we sit here today, Adnan Syed is a convicted murderer once again. And this opinion really doesn't focus on innocence or guilt at all. I mean, obviously, they give a background to the case, which I'm going to go through with you. And I think that it's a very, very interesting opinion. Fundamentally, I think that I know some people aren't going to want to hear this. It's the right call. I think that victims do have rights, and I think that those rights should be followed and noted by the court. That being said, the fact that this thing's here is quite a cluster. This could have been easily avoided. Easily avoided. And I've listened to some other podcasts. Specifically, I listened to the prosecutors. I wanted to hear what their take on this was. Obviously, everybody that has listened to their series on Syed knows what their position is. They're firmly in the camp that Adnan Syed is guilty of what he was convicted of, and no one's changing their mind on it. I'm not nearly as convinced. Their series did not convince me. And that's just the way I feel about that. And I listened to it thoroughly. You know, I always do. I always listen to both sides because that's the only way that you can form an opinion. If you form an opinion hearing one side of an argument, I don't give it much weight. You have to hear both sides of an argument. You have to hear different interpretations of the same facts in order to reach a conclusion on anything, not just in a court of law, but in life. So I was not convinced by their coverage. I was not convinced by Alice's closing argument, which was, again, I've said it before, it was really well done, really well done, very compelling, but it was all based on emotion, not facts. And I know that they are currently battling on Twitter with Colin Miller as they've decided to dip their toes back in. Pretty sure that I'd be being called a grifter if I were to dip my toes back in on Syed, but I don't know. The world's funny like that. So, all right, the way that I want to do this, I'm not going to assume that everybody has all the background and knowledge about this case. I'm assuming that a lot of you do. Um, but what I'd like to do is just like the Times, New York Times had a pretty nice little kind of like breakdown of kind of the overall theme. Now, Allie is currently babysitting our granddaughter. I was on the early shift. I was on the early duty, which was glorious, but short-lived, too short-lived. And then she came and took over for me. So, but I had to make it home anyway. I had to prep for this. So, but I think this New York Times breakdown, which just dropped, I think right after the Supreme Court, Maryland Supreme Court's decision came down, um, this hit, and it's not overly thorough, but I think it's a good preface and kind of giving you an overview and kind of giving you the basic timeline. And then what we're going to do is we're going to shift into the opinion itself, which is massive. There's the majority opinion, and then there are a couple of dissents. I'm certainly not going to read it all. It's 187 pages. I'm going to focus on the procedural background that they give in there. It's a very thorough opinion. It's a very, very thorough opinion. They clearly put a lot of thought into it. They obviously have long thoughts on victims' rights. And they didn't make new law there at all. They were basically saying it existed and that it wasn't followed. They're not reinventing the wheel with that opinion. They're simply saying, look, this is the bottom line. This stuff was all here, right here for you, and you guys simply and and again, I'm going to be a little critical of the prosecutor's coverage. They were quick to fire on the defense and the judge, but I am here to tell you that the prosecutors in that case are equally, if not more, culpable than everybody else in terms of not giving proper notice to Hae Min Lee's family. They were the ones who filed the motion to vacate. And I'm going to get into that conversation. I've had it many, many times. And if you guys listen to our Syed coverage, I'm not at all surprised at where we're at. As a matter of fact, if you go to any of our podcast episodes on it, I'm fairly certain I said this is exactly what I feared was going to happen. And it could have easily been avoided by just giving Hae Min Lee's brother 7 days so that he could arrange to get to this hearing back when it was happening. And it didn't happen. So, all right, let me share this thing here. All right. So again, this is New York Times. It's published on August 30th of 2024. It's pretty interesting. This is the timeline for the Adnan Syed case. And it's basically Syed was the subject of the 2014 podcast Serial, which like many of us in the podcast world, especially in the true crime podcast world, Serial is what drew me in. Serial was the first podcast I had ever listened to of any type, and I was hooked immediately on the whole platform. I loved it. I love storytelling. I love that they were incorporating it. It's different than reading a book because you're hearing interviews with people. It's different than watching a documentary because they can just get more in depth. You're not going to have out of 800 hours that are filmed, 798 of those hours on the cutting room floor. You can be as thorough or as surface level as you want to be in a podcast. I happen to be, I think, probably the deepest diver in the game, maybe challenged by Josh Hallmark, but we do different things. Um, but I love Josh. He's a dear friend, and he's got an amazing podcast, which is True Crime Bullshit, which, by the way, if you are in and around the Berkshires, October 18th, you should definitely come to the Berkshire Podcast Festival because we will be there along with a ton of amazing pods, including, of course, Josh. It's his festival. And that is sure to be a great, great time and just the most beautiful setting you could ever imagine. I'll have Dizzy throw up the code. There's a new code for a tasty discount for those that might be interested in joining us out there. Super intimate podcast festival where you're just going to get a lot of quality time with the creators that you would probably enjoy hanging out with and shooting the shit with, including myself and Allie. We will definitely be there and definitely be hanging. So, all right, let's dig into it. I'm just going to read it again. Daniel Victor and Remy Tooman wrote this for the New York Times, August 30th of 2024. Always like to give credit for credit is due. So Adnan Syed spent more than 2 decades in prison while fighting charges that he had killed his former high school girlfriend in 2022, and in 2022. A judge vacated his conviction, but a ruling by the Maryland's highest court in August could affect that outcome. The Maryland Supreme Court ordered a trial to redo the hearing that freed Mr. Syed, whose case received widespread attention in 2014 after the Serial podcast raised questions about the conviction. The state Supreme Court decision followed an appeals court ruling in March of 2023 that reinstated his murder conviction. Now that was stayed. Okay, so we'll go through that. We'll go through that when we get to the actual document. The Maryland Supreme Court does a very nice job of breaking down the procedural posture of the case. So Mr. Syed has maintained his innocence throughout the long-running legal saga. And you know why I really wanted to cover this? Because this is a perfect example of how incredibly difficult it is once you are convicted in a court of law in this country to get it overturned. I mean, in terms of kind of a spotlight being shown on a case, you cannot get a case that had more attention drawn to it than this case. I mean, Serial was a massively, massively popular podcast and turned this case into a case that nearly everyone is aware of. Everyone that is into true crime has heard of this case, and everyone pretty much knows the factual background about it. And that being said, all of that being said, it's still it's a great example because it's right there for all of us to see just how difficult it is to overturn a conviction in this country. It's just, I say it all the time, it's Herculean. It's a massive undertaking that most of the time falls flat on its ass. So, this is just one of those occasions where this probably could have been avoided with one easy move, in my estimation. But we'll get into that part of it. Okay, so in 1999, Hae Min Lee is killed. There's a picture of Syed and Hae Min at their prom. That was courtesy of HBO on their doc, which was pretty good. The case against Adnan Syed. So Hae Min Lee, 18, was killed by strangulation when she was a student at Woodlawn High School in Baltimore County, Maryland. She disappeared after leaving the school, and her body was found nearly a month later, buried in a park. A police investigation led to Mr. Syed, a fellow student who had dated Miss Lee. He was arrested and pled not guilty. So in 2000, Adnan Syed is found guilty. So prosecutors relied heavily on testimony by Jay Wilds, who was a friend of Mr. Syed's, who said that he had helped Mr. Syed bury her body. They presented cell phone tower records that they said placed Mr. Syed near the park where Miss Lee's body was found ultimately. The jury found Mr. Syed, who was 17 at the time of Miss Lee's death, guilty of murder, robbery, kidnapping, and false imprisonment. He was sentenced to life in prison. So in 2014, so you can see there's a huge gap in time. So he's convicted in 2000, and then in 2014, serial drops. So 14 years later, the Serial podcast raised doubts about the facts around the case. Over the course of 12 weekly episodes, the podcast revealed the existence of an alibi witness for Miss Syed, who said she was with him at the library when Miss Lee was killed. The witness, Asia McLean, said that she had been willing to testify, but Mr. Syed's lawyer, Maria Cristina Gutierrez, did not contact her. Ms. Gutierrez was disbarred in 2001 after a series of client complaints emerged. The series also questioned the credibility of the cell phone tower records and revealed that physical evidence gathered in 1999 was never tested for Mr. Syed's DNA. Now, obviously, in 99, DNA is nowhere near what it is now in terms of them being able to create profiles, being able to create more thorough profiles. And, so that was always a thing that was later, especially in the post-conviction relief act type petitions, that was being focused on. The podcast was downloaded over more than 100 million times in its first year, bringing widespread public attention to the case. It won a Peabody Award for its compelling, drilling account of how guilt, truth, and reality are decided. In 2015, Mr. Syed gets a new hearing. So in February of 2015, a Maryland court agreed to hear an appeal from Mr. Syed. In November, a judge granted him a new hearing that would allow the introduction of new evidence. In 2016, a judge grants a new trial. In the hearings, Mr. Syed's defense team argued that his original defense had been grossly negligent and presented the testimony of Ms. McLean, the alibi witness. The team also asked why the original lawyer had not questioned the reliability of the cell phone tower records. A judge in Maryland granted a new trial in June, and the state appealed the ruling. Miss Lee's family expressed pain and outrage at the decision to grant a new trial, saying that they, quote, continue to believe justice was done when Mr. Syed was convicted of killing Hae, end quote. Mr. Syed's lawyers asked for him to be released on bail. The motion was denied. Go to 2018, Mr. Syed wins another appeal. Maryland Supreme Court of Special Appeals upheld the decision to grant Mr. Syed a new trial and vacated his conviction, agreeing that he had received ineffective legal counsel. He remained incarcerated. So that's 2018. This is not the vacated conviction that we're talking about now. No, it still has a long, winding road before we get to where we're at now. 2019. So the Maryland's highest court denies the new trial, reversing the decision from 2018. Maryland's highest court, Court of Appeals, ruled in a 4-3 decision that while the original defense lawyer had been deficient, Mr. Syed was not prejudiced by that deficiency. It denied him a new trial and reinstated his conviction. In November, the U.S. Supreme Court declined to hear his case, so they had tried to apply to the Supreme Court to see if they'd grant certiorari. They would not, so Supreme Court didn't hear it. So then in 2022, this is where we get to where the story that we're now covering starts in earnest. So in March, prosecutors agreed to new DNA testing, saying that it was merited because of the advances in genetic profiling. A new Maryland law gave prosecutors the discretion to modify the sentences of offenders who were under 18 at the time of their crimes and had served at least 20 years in prison. On September 14th, prosecutors asked a judge to overturn Mr. Syed's conviction. They said an investigation had uncovered the potential involvement of two, quote, alternative suspects, end quote, key evidence that prosecutors might have failed to provide to Mr. Syed's lawyers, and, quote, significant reliability issues regarding the most critical pieces of evidence, end quote, presented at trial. So on September 19th, Judge Melissa Finn of Baltimore City Circuit Court vacated the conviction, quote, in the interests of justice and fairness. Mr. Syed, 41, walked out of prison and served home detention while awaiting word on whether prosecutors would proceed with a new trial. So when we I love this for you guys because this is giving you the background kind of in layman's terms to when we switch over to the opinion and they're talking about procedurally what happened. They get into the nitty-gritty, the details of all of this in the opinion. So the charges are dropped. Prosecutors dropped the charges against Mr. Syed on October 11th. The Maryland Office of the Public Defender said the charges were dropped because the DNA evidence excluded Mr. Syed. An appeal before the Maryland Court of Special Appeals, in which Miss Lee's family sought to pause proceedings, remained pending. 2023, the conviction is reinstated. The Appellate Court of Maryland reinstated Mr. Syed's murder conviction on March 28th, ruling that the lower court had violated the right of young Lee, a brother of Miss Lee, to have been notified and to attend the hearing in September when a judge vacated the conviction. In a 2-1 decision, the appeals court ordered the trial court to hold a new hearing on the motion to vacate Mr. Syed's conviction that would give Mr. Lee enough notice to attend in person, unlike the previous hearing, which he joined via Zoom. The decision did not mean that Mr. Syed had to immediately return to prison because the appeals court issued a 60-day stay of its ruling to give both sides time to consider next steps, said David Sanford, one of Mr. Lee's lawyers. 2024, Maryland's highest court orders a redo. So the Maryland Supreme Court ordered the trial court to redo the hearing that had freed Mr. Syed, agreeing with the appellate court. The appellate court's 2023 ruling that Mr. Lee's rights had been violated when he was not given enough time to attend the hearing. The state Supreme Court held the appellate court's decision to reinstate his conviction. So the high court's ruling said that the prosecutor gave Mr. Lee, quote, less than 1 business day's notice for the in-person hearing, and that his request for a 1-week postponement was denied. That's what I'm talking about. This was the prosecutor's game. Like, the prosecutors are the ones who filed this thing. Like, to be honest with you, Syed's appellate journey, as well as his post-conviction relief act journey, was for all intents and purposes, unless some truly newly discovered evidence somehow came about, he was done. Like, he had run the course. I mean, at that point, when the high court had turned down his last shot at a retrial, he was done. It was the prosecutor's office, which we'll get to, which I've talked about many times. This vacatur statute that is relatively new in Baltimore, and again, I've told you guys many times, go watch We Own the City by David Simon. It's all about the gun trace task force in Baltimore, this rogue band of disgusting cops that was just so out of control that they couldn't even put cops on the stand to testify in tons and tons of cases. They were untouchable because they couldn't be trusted. So there were so many crimes that band of cops had committed, and there was no legal vehicle in place for a prosecutor to be able to say, all right, well, uh, yeah, we don't trust this conviction because we just found out these cops were framing everybody. So they had no way to file. They had no, because it's typically done by us, by the defense attorneys. We are typically filing the post conviction relief acts, trying to get new trials, trying to get evidentiary hearings. That's us. It's not the state. The state never does it. So because of all the tomfoolery and shenanigans and ballyhoo by the Baltimore Gun Trace Task Force, this statute was created by the legislature over there in Maryland. And that is what Marilyn Mosby used in order to go into court on the state's motion, which they gave Mr. Lee 1 day notice that they were doing it. So, like anybody talking about pointing fingers and not pointing fingers at the prosecutors in this case is completely disingenuous. And that like I've got long thoughts on how prosecutors deal with victims' families post conviction. Like they just don't give them any information about what's going on, which for the families, as you'll see in this case, especially, have no clue what's going on. And beyond that, they don't understand how the legal process works. So they're sitting there in a constant state of fear every time they read an article in a newspaper or see some kind of story on some kind of news program that, that their family member's case is like in jeopardy of being reheard or the conviction's going to be vacated, and they have no idea how it comes about because prosecutors just don't inform the victims' families of what the hell's going on. And that's not just on this case. It's all the time. It's all the time. I'm complaining about it all the time. Like people just don't have an idea if you're not in the practice of law and if you're not in the practice of criminal law, what's going on. I mean, you have to have somebody advocating for you on the front end, but you also have to have them educating you on the back end, or at least keeping you informed on what the hell's going on with the case. I mean, it's crazy that a victim's family has to hire a lawyer in order to be made to understand what's going on with their loved one's case. But that's what happened here. So the court's high ruling said the prosecutor gave Mr. Lee less than 1 business day's notice for the in-person hearing, and that his request for a 1 week postponement was denied. Mr. Syed will remain free pending a new hearing. So that's that. All right. So let's get to the big guy. Get this guy up here. And it's a long one. It's a long one. Like Allison would kill me. She's like, "You're not going to read it all, are you?" I'm like, "No." And then, of course, I start reading, highlighting it, and I'm like, "Oh boy, I don't want to read it all." But it's way too big. It's way too big. So, like, what I might do is break it down into like a couple of different episodes. Um, but I want to kind of get through at least the procedural posture, and then if you guys have questions, try to answer those. And I like the way that they wrote the opinion here because like instead of having to read through the entire document or skipping everything and just getting to the end to see the way that they ruled, they're kind enough to give us the way they ruled right at the beginning of the document before the caption even. So that's thoughtful of them. All right. All right. And so, mods, if you guys are seeing good questions in there, because y'all, I'm not looking at the chat. You guys know how it is when I'm reading. I'm not typically looking at chat, and I do want to read read questions and address questions as they come. So if you guys will, my mods will be kind enough to star any questions that you think are um, in need of answering, just let me know and stick them on there. And then when I'm done, I'll get to them. All right. So these are the primary issues. And again, remember this really has nothing to do with the court weighing in on Syed's innocence or guilt at all. Now, again, they're going to go through the factual background of the case within the opinion itself, but that's not what they're doing. They're narrow issues that they're ruling on, and these are them. Okay, so appellate jurisdiction mootness, the entry of nollie pros uh, after vacature of conviction. All right, so a nollie pros is simply when the state decides not to proceed with the case. They dismiss it. And with a nollie pros, they can bring back the charges. Nollie pros isn't with prejudice, meaning it's not dead in the water and that they can never come back. Oftentimes, we've had the state in cases that Ali and I have handled, they nollie pros it. And on some occasions, they come back with the case. But there is a time frame for them to do that. But so and again, when we get into the nut, like kind of the nuts and bolts of what's behind this little argument here, you'll have a better idea. So the Supreme Court of Maryland held the entry of the nollie pros by the state's attorney did not moot the appeal by the crime victim's representative of an order vacating a defendant's convictions under the Maryland Code. The lawful vacature of the defendant's conviction was a condition precedent to the state's attorney regaining the authority it had prior to the entry of a final judgment to nollie pros the charges. Now they call it null pros here in Illinois. We call it nollie pros. The prosecutor may not use the null pros power to divest a victim of the right to appeal what the victim contends is an unlawful vacature order. All right. So if you guys don't know what mooting is, mooting means it's become irrelevant. It's of no consequence anymore. It's been mooted out. And what happened here is, and again, they'll get into it in the actual opinion, but essentially what happened here is they run into court, they give Lee a day's notice. They're like, hey, by the way, just wanted to let you know we're vacating the conviction on your sister's case. And he's like, what? What do you mean? What's that mean? And she's like, oh yeah, well, it's like we dug into it. We did a year-long investigation and we don't trust it. We don't think that it's a trustworthy and just verdict. And the conviction has to be tossed. So he's like, wow, okay. And then he obviously goes and talks to his family. They're all extremely upset, as I think anybody would be in that type of situation where you're given no notice, no warning, no heads up. Hey, just want to let you go. Like, give them a call when you're starting the investigation. Just wanted to let you know we're taking a look at the case again, and we will keep you advised as to what we find out. None of that occurred here. It's just surprise, surprise. The guy that we said was the right guy, the guy that we promised you was the right guy, the guy that the cops told you was the right guy. Everybody from the government side told you was the right guy. Well, we're saying now he's not the right guy. We're sorry. We're sorry about that. Yeah, like I have to be honest, like from the victim's family side of this, I'm like 100% with them. Like I know that Syed supporters are like furious about this, but don't blame the family of the victim. They didn't ask for anything outrageous here at all. At all. What they asked for was more than reasonable, and this could have been avoided with just a modicum of thought and graciousness to the victim's family of a week, 7 days after 2 decades had gone by. It's it's crazy. I thought it was crazy when I heard it, and then I completely predicted all this was gonna happen completely. It's like it's in the podcast. It can't be denied that I completely like it was just yeah. All right, so the victim's rights, motion to vacate, victim's rights to be heard. Supreme Court held that a victim has a right to be heard at a vacatur hearing. The vacatur statute itself does not reference a right to be heard at a vacatur hearing. A more general victim's rights statute, which is CP 11-403, provides a right for a victim to be heard at a hearing where there's, quote, an alteration of a sentence, end quote, is considered. And obviously, If you're vacating conviction, I would certainly consider that to be an alteration of a sentence, which includes a vacatur hearing. So, in addition, Article 47 of the Maryland Declaration of Rights mandates that the General Assembly implement a victim's right to be heard at a criminal justice proceeding where it is practicable to do so. The General Assembly may not create a new criminal justice proceeding without affording victims the right to notice, attendance, and to be heard at such new proceeding unless the General Assembly makes clear on the face of the legislation or in unambiguous legislative history that it finds it would not be practicable to provide one or more of those rights to victims with respect to the new criminal justice proceeding. If, as is the case with CP 8-301.1, there has not been a legislative finding of impracticability, a reviewing court must consider whether the new criminal justice proceeding is similar to one or more extant criminal justice proceedings where the General Assembly has previously granted victims the rights that is missing with respect to the new criminal justice proceeding. So what they're saying there is you got to find the equivalent. Like look for the equivalent. If there's not one that's on point, if there's not one that's exactly, and again, this is a brand new statute where the prosecutors are the ones who are able to go in and vacate a conviction. So this is not going to be the type of situation where the appellate courts have sounded off on it. It's just it's a new statute. It's very rare. It had never happened. I don't know if this is the first vacatur that they had used. I imagine that it's not, but they'll get into it again deeper into this opinion where they're talking about there were two things that had happened that required the legislature to come up with this ability for the prosecutors and the state to be able to go in and say, okay, we're going to vacate these convictions. One was the legalization of marijuana. And obviously everybody that was rotting in prison on a bullshit weed charge, they were all vacated. They were all freed as they should have been. And then the gun trace task force. So those two things were the motivating factors for the legislature to draft up this new law. All right. So the General Assembly had previously granted victims the right that is missing with respect to a no criminal justice proceeding. The court held that a hearing where the alteration of a sentence is considered is similar enough to a vacatur hearing to require the provision of a right to be heard at the latter proceeding. The court also held that a victim has the right to be heard on the merits of a new vacatur motion after hearing the parties' presentations in support of the motion, including the right to speak through counsel if the victim is represented by counsel. However, a victim does not have the right to participate as a party at the vacatur hearing. All right, so what you're seeing here, they're giving you their ruling, okay? Their rulings are the last sentences on each. So as far as the mootness issue, the ruling was that a prosecutor may not use the nollie pros power to divest a victim of the right to appeal what the victim contends is an unlawful vacatur order. So the rule here is that the court held that a hearing where the alteration of a sentence is considered is similar enough to a vacatur hearing to require the provision of a right to be heard at the latter proceeding. The court also held that a victim has the right to be heard on the merits of a vacatur motion. This is a big one. This is the biggest difference between what the appellate court had ruled and what the Maryland Supreme Court had obviously ruled. And this is the highest court in the state. This is the law of the land over in Maryland now. So this changes the game for victims in terms of, like, we're all used to hearing victim impact statements at sentencing, right? I mean, we get to hear the families and we have to, digest those just heartbreaking stories that you're hearing from these family members. So that's been a thing for a while. This is different. This is where they're able to actually speak on the merits of the motion itself. It's different than saying, this is how my loved one's death like just devastated our family. And this is the person that we lost. And these are all the things that that person was to us and to the world. That's different. This is where you're saying, okay, I heard both sides give their presentation in terms of the merits on this thing, and we're concerned. We still believe that they got the right person. Like we heard what in this case the state is saying in terms of why this should be vacated, but we disagree. We think they got it right the first time. So like, but then it continues on, and it says the court also has held that a victim has the right to be heard on the merits of the vacatur motion after hearing the parties' presentations in support of the motion, including the right to speak through counsel if the victim is represented by counsel. However, a victim does not have the right to participate as a party at a vacatur hearing. Now, that part means they cannot come in and present evidence. Like so young Lee through his attorney can't say, all right, we're going to hire a private investigator and we're going to go dig up a bunch of stuff and we're going to come in trying to seek to introduce evidence into this case. They're not parties, so they can't do that. They can talk on the merits, they can speak on the merits, they can give their opinion on the merits through counsel, but they can't come in trying to introduce new evidence and trying to litigate the matter in that sense. Okay, so it's two different things. All right, so the victim's right. So this is the third issue. So we've gone through two of the issues that they dealt with. So the victim's rights, motion to vacate, victim's right to attend a vacatur hearing. So the Supreme Court held that a victim has a right to attend a vacatur hearing in person. A court must ensure that a victim receives a reasonable opportunity to attend a vacatur hearing in person. Okay, so that pretty plain and simple right there. Like they're adamant. Like they were furious with the way that the judge handled the whole 7-day request thing. From Young Lee and his attorney, just trying to make it so that he could be there in person because they live in California. Talking about Maryland, most of us can't just drop what we're doing and then go fly out to a different state with no notice. We all have moving parts. We all have jobs. It's not easy to do. All right. So the next issue they address is the victim's rights, motion to vacate, victim's right to notice of a vacatur hearing. So the Supreme Court held that a victim has a right to reasonable notice of a vacatur hearing. Reasonable notice is notice that is sufficient to permit the victim to attend the hearing in person. Now that's so you're not going to get like a red line rule for what is reasonable, right? Like what constitutes reasonable notice. They'll typically take those by a case by case basis. And I can tell you this, the Maryland Supreme Court certainly thought that 7 days, a 7-day continuance to just give him proper notice, that they thought that that was more than reasonable. All right. And then the last issue, victims' rights, necessary showing of prejudice. So the Supreme Court held that in order for a victim to be entitled to a remedy, the victim must show that an error prevented the victim from exercising their rights in a meaningful manner. Okay. So those are the issues. And then we get into the actual case itself. And like I said, it's very, very lengthy. Like this first portion, I think I'm just gonna skip this. So they kind of give you an overview in the beginning. They then give you a real nice breakdown of victims' rights in this country, starting from the get. Like they go way back, way back, like before our country. They go into medieval times, and then so they're trying to explain why victims' rights matter and how there's been shifts in terms of how it's perceived and how back in the olden times that prosecutions were private, and then as our country began to evolve, we began to realize that, look, crime isn't just affecting the one individual, it affects all of us as a society. And that's when prosecutions became public. That's when the government took it upon themselves to start prosecuting cases on the behalf of its citizens. So that's why when you see captions, it always says the people of the state of, whatever state you're in. It's because the government is working on behalf of not just the victim of that crime, but of society. That's what the concept is. All right. So I'm not going to read through this, even though it's a very interesting read. If you're a law nerd, I highly recommend you check that part out, because it really goes to the heart of why this opinion's so lengthy. They obviously spent a lot of time um, coming to a real understanding of how victims' rights developed, specifically in our country, and going back a long, long way to figure it out. And brick by brick, they build the house in terms of victims' rights in this country. All right. Okay. So the second one's where I'm going to start, and this is the vacatur statute and implementing the rule. So in 2019, the General Assembly enacted CP 8-301.1, the vacatur statute. And the legislative history of the vacatur statute indicates that its enactment was a response to two recent developments: the decriminalization of marijuana, and revelations concerning the misconduct of the Baltimore Police Department's gun trace task force. So these developments led the General Assembly to create a post-conviction remedy that a prosecutor may invoke to vacate convictions as an alternative to requiring convicted defendants to seek relief through other procedures, i.e., appeals, post-conviction relief act petitions, and things of that nature. All right. So the vacatur statute allows a court with jurisdiction upon the state's motion at any time after the entry of a judgment of conviction in a criminal case to vacate the conviction if two conditions are met. First, that there is newly discovered evidence that could not have been discovered by due diligence in time to move for a new trial under Maryland Rule 4-331C. And the newly discovered evidence, quote, creates a substantial or significant probability that the result would have been different. So that's the first one. So there's two parts to it. And then there's an or. So it's an either or. You don't have to have both of these. You can either have the first one. The first is that there's newly discovered evidence, and that newly discovered evidence creates a substantial or significant probability that the result of the trial would have been different. Or the state's attorney received new information after the entry of a judgment of conviction that calls into question the integrity of the conviction. And then second, the interest of justice and fairness justifies vacating the conviction. All right, so that's an either or proposition. Mosby, they kind of came under both, but they really came under the second one. All right. The state must file a motion to vacate in writing. The motion must, quote, state in detail the grounds on which the motion is based and, where applicable, describe the newly discovered evidence. The motion must contain or be accompanied by a request for hearing. Now, back when the Baltimore County State's Attorney's Office dropped this thing, Allie and I did a few lives on it. You should go back and listen to them. They're pretty interesting, and like all the way through, which Allie and I covered. We streamed the actual hearing where they vacated the conviction, if you want to call it that, if you want to actually call it a hearing. That's part of the problem. That wasn't really a hearing at all, what took place that day, and they get into it here. So the court may dismiss a motion to vacate without a hearing if the court finds that the motion fails to assert grounds on which relief may be granted. Otherwise, the court must hold a hearing on the motion. So, and what's interesting here is that you've got the state as the moving party. Okay. And in a criminal case, when you have the state as the moving party and what they're moving to do is to vacate a conviction that they had secured, you are never going to have a defendant that's going to oppose them. All right. So at this point, you've got two parties that are the only two parties in the matter that are in complete agreement in terms of what should happen. Now, that being said, it's kind of akin to a plea deal. So like if Allie and I have worked out a plea deal on a case and we've worked it out with the state, especially in state cases, it's different in federal cases. The sentencing guidelines are a whole different beast. I should force Allie to do a super long federal sentencing guidelines live with you guys. I mean, it's a whole different thing than state court. But at any rate, so you've got this situation where you've got two parties that are very much on the same side of what should happen in court. But like I said, in a plea agreement, that happens all the time. Like where we will ultimately work something out with the state in terms of whatever the sentence is going to be, whatever the penalty is going to be. And we say, all right, let's motion it up, let's plead it out, but we still are beholden to the judge. We can agree all we want, all day, every day, between us and the state. We can come up with agreements, we could write it all up. Here you go, judge. The state's like, yep, we're good with it. And the judge can say, I'm not. I'm not good with it. I've had it happen a couple of times. It's always shocking because most of the times judges are happy to get things off their docket, and they assume that the state and the defense did good work on it, came to what they felt was a reasonable um, solution for the case, and typically the judges will approve of it. With this, it's different. And you just got the feeling in this thing, the way that it went down, that it was like a foregone conclusion that the judge was going to grant it. You know what I mean? I just got that vibe. And like in terms of looks, to me, that's not a great look. Like you don't want it to seem like the judge had tipped her hand and saying, "Yeah, I'm gonna grant this thing." Like, cause you should really go in not knowing what a judge is going to do. I mean, that's just how the system works. Like the judges aren't giving us heads up on the way they're ruling on things ever. So and maybe that was just an assumption. Like I'm saying, when we have a plea agreement with the state, which is very similar to this in terms of function, that we just assume that the judge is going to be cool with it. So like maybe that's what it was. But as the thing kind of played itself out, like going into that hearing, I was really expecting to hear a lot more of what the state had dug up in their 1 year of investigation into the case. Like, and I said it in our podcast on this at the time that this hearing went down, and I'm talking about back when they vacated the conviction initially, this time, that I was just confident that an arrest was imminent, that one of these two alternate suspects, that they had got some kind of return on DNA that was sufficient enough, along with other evidence that the state had collected, to move on one of these alternate suspects. I was just of the mindset, because of the timing of it and how quickly they pushed it through, that was going to happen in very short order. And then days passed, weeks passed, months passed, and it became evident that that was not happening. And, you know, obviously young Lee was upset. The whole Lee family was upset. So upset that they went and hired an attorney who frankly has done a very, very nice job in advocating for his clients. Because people were like, "Oh, this is bullshit, blah, blah, blah." The victims are like, look, I'm a defense attorney. I represent defendants for a living. Victims have a right to have a voice at these matters. I mean, like I've said it a million times. Look, the process itself, the trial itself, is all about the defendant, but we can never forget why we're there. I mean, you can't forget why we're there. Somebody, if it's a murder case, somebody lost their life, and it's devastating. And I think that those people have an absolute right to be heard. They certainly have a right to be properly notified that this is going on, and they certainly have a right to be there because it affects their lives. It's like an ongoing scab that keeps getting picked and it just never heals. So in terms of like how I feel about it personally, I'm with the court on this in terms of the concept of what they're making clear to the state of Maryland in terms of how victims' families are to be treated moving forward. Now, how it's going to affect that, uh, this case in particular, that's a conversation we're going to have because this thing may absolutely go sideways for Syed. He's currently out of jail. If somebody's asked the question here, he's still not in. He's still out. Um, there's going to be. I don't even want to jump ahead, but like that's the part of this conversation that is like so fascinating to me because I have no idea what the new state's attorneys because Mosby's out. Like she had some federal charges for some fraud that she was conducting, like bilking money out of the government, like COVID scams or something. So she was gone out, and so there's a new Baltimore County state's attorney, and I have not seen nor heard anything about what his position is with respect to this. And we are back to just prior to the hearing taking place. So this motion has been filed. Now the question becomes, well, I'm jumping ahead. Yeah, see, as soon as I start thinking about it, I want to start talking about it. Okay. So the court may dismiss a motion to vacate without hearing if the court finds that the motion fails to assert grounds on which relief may be granted. So the vacature statute states that before such a hearing that the victim or the victim's representative shall be notified as provided under 11-104, 11-503 of this article. In addition, the statute provides that a victim has the right to attend a hearing on a motion filed under this section as provided under 11-102 of this article. The vacature statute does not mention a victim's right to be heard at a vacature hearing. So then they footnoted it here, which I love. I love footnotes. You can find just the best gems, but this thing's so long, I'm not going to read through the footnotes. But you can always read the footnotes. Like if you're reading privately, you can just find the best stuff in the footnotes. Okay, so at the hearing, the state has the burden of proof. In ruling on the motion to vacate, the court, as the court considers appropriate, may either vacate the conviction or deny the motion. The court shall state the reasons for ruling under this section on the record. Okay. Among other things, the vacature rule specifies that notice to a victim must, one, be in writing, two, contain a brief description of the proceeding, three, inform the victim of the date, time, and location of the hearing, and four, inform the victim of their right to attend the hearing. After setting forth the provisions related to the conduct of a vacature hearing, the vacature rule cross-references, which, as discussed above, gives the victims the right to be heard as sentence-related proceedings. Cross-reference for the right of the victim or victim's representative to address the court during a sentencing or disposition hearing. So see, that's what they're doing. They're cross-referencing different types of matters because there's been nothing like directly on point. And again, that absolutely goes to the fact that this is a brand new statute. All right. All right. So now we're going to get to the procedural history. And I see the questions, y'all. I'll get to them. I promise. I promise. So procedural history, 1999 through 2019. On February 9th of 1999, the body of Hae Min Lee was discovered buried in Lincoln Park in Baltimore City. Ms. Lee's ex-boyfriend, petitioner cross-respondent Adnan Syed, was eventually charged with first-degree murder and related crimes. The state's key witness at Mr. Syed's trial in the circuit court for Baltimore City was Jay Wilds, who testified, among other things, that Mr. Syed confessed to him that he had murdered Miss Lee, and then and that Mr. Wiles, assisted Mr. Syed in burying Miss Lee's body in Leakin Park. The state also introduced records which, according to the state, showed that Mr. Syed's cell phone received an incoming call around the time that Mr. Wiles testified that he and Mr. Syed were burying Miss Lee's body, and that this call registered with the cell tower, which was the strongest cell site for the location of Miss Lee's body in Leakin Park. Miss Syed's palm print was found on the back cover of a map book found inside Miss Lee's abandoned vehicle. The map showing the location of Leakin Park had been removed from the map. That torn out piece was found in the rear seat of Miss Lee's car. So on February 25th of 2000, Mr. Syed was convicted of first-degree murder, kidnapping, robbery, and false imprisonment. He was sentenced to life in prison plus 30 years. The appellate court of Maryland affirmed his convictions in an unreported opinion after his direct appeal. So in 2010, 10 years later, he filed a petition for post-conviction relief. He alleged ineffective assistance of counsel concerning his trial, sentencing, and the appeal. The post-conviction court initially denied Mr. Syed's petition. Mr. Syed then filed an application for leave to appeal, which the appellate court granted. The appellate court subsequently granted Mr. Syed's request for a remand to consider a newly obtained affidavit from a potential alibi witness. So on remand, the post-conviction court granted Mr. Syed a new trial. The state then filed an application for leave to appeal, and Mr. Syed filed a conditional cross application for leave to appeal, both of which were granted. Same thing that happened here. Okay, so both of which were granted. In 2018, the appellate court affirmed the granting of a new trial. So after granting the state's petition for writ of certiorari, this court reversed the judgment of the appellate court and held that Mr. Syed was not entitled to a new trial. So, like, this is where I just kind of want to point out, like, so Syed's obviously tortured. Like he's like, oh my God, I'm gonna get a new trial, and then the Maryland Supreme Court snatches it away. And like on the other side of it, you've got Hae Min Lee's family sitting there having no idea what any of this means, hearing that he's getting a new trial, then hearing he's not getting a new trial. It's just like having been in the system, I'm just acutely aware of how little that victims' families are made aware of what is going on, especially post-conviction. It's a fact. Like the prosecutors do not call and let them know when an appeal has been filed. They don't call and say, hey, do you have any questions about this appeal? I want to go through it with you. It's like they're done. They're done with the case. They're done talking about it. They're done talking with the victims' families. So it's like these victims' families all over the country just sit there having no clue what's going on in cases that never seem to end. Okay, so then we get into the motion to vacate Mr. Syed's convictions. In 2021, Erica Suter, Mr. Syed's current counsel, approached Assistant State's Attorney Becky Feldman about pursuing a Juvenile Restoration Act motion on behalf of Mr. Syed. Now, this footnote I actually want to read to you. So the Juvenile Restoration Act, because we actually had our Allie and I's first client, Muti, this was an act that they had passed probably in the last 7 or 8 years in Philadelphia and Pennsylvania. And it was similar because our first client had been convicted when he was under the age of 18. It had been given a life sentence without the possibility of parole. So this Restoration Act allows certain individuals to file a motion for sentence reduction to qualify for potential relief under the JRA. An individual must have been, one, convicted as an adult for an offense committed when the individual was a minor, and two, sentenced for the offense before October 1 of 2021, and three, in prison for at least 20 years for the offense. Okay. So all of those things were obviously in place as far as Syed goes. So the discussions between Ms. Feldman and Ms. Suter eventually led them to conduct a joint investigation concerning the integrity of Mr. Syed's convictions. Now, just so you know, Becky Feldman, she is before she was in the prosecutor's office. She's one of those rare folks that goes not from prosecutor to private defense counsel, but went from defense counsel to the prosecutor's office. She wanted to try to address the issues from the inside on the state side of things, which I I respect because it's really hard to do from the defense side of it. You almost need more defense attorneys going in on the prosecution side in order to get to like try to balance what's going on over there with with those folks. So as part of that investigation on March 10th of 2022, the state and Mr. Syed filed a joint petition for post conviction DNA testing of Miss Lee's clothing using procedures that were unavailable at the time of Mr. Syed's trial. In addition, on May 12th of 2022, Ms. Feldman requested that Mr. Syed's trial file from the Maryland Attorney General's office. In the course of reviewing the state's trial file, Ms. Feldman discovered what she believed to be exculpatory information in the form of two handwritten documents that detailed two separate interviews. According to Ms. Feldman, these interviews included information concerning two suspects other than Mr. Syed who had possible motives to harm Ms. Lee. Ms. Feldman informed Ms. Suter of the discovered documents. Ms. Suter told Ms. Feldman that copies of the two documents were not in the defense file and that nothing in the defense file resembled in any way the information contained in these two documents. So then the vacatur motion comes. So on September 12th, so this is where we get into like how this thing fell apart for Syed. So on September 12th, 2022, Ms. Feldman informed Mr. Lee's brother. So just note the dates here. So remember, they started investigating 2021. They started having chats, and then they're working through it, and then they filed a joint petition for post-conviction DNA testing, and then May goes by. They're obviously talking a lot. And then on September 12th, Ms. Feldman informed Ms. Lee's brother, respondent cross petitioner Young Lee, that the state would be filing a motion to vacate Mr. Syed's conviction. Ms. Feldman was aware that Mr. Lee lived in California. In a telephone conversation on December 13th, Ms. Feldman interviewed the motion with Mr. Lee and told him that there would be a hearing on the motion to vacate. She also provided her contact information to Mr. Lee. Ms. Feldman followed up with Mr. Lee via email on the afternoon of September 13th. So she drops the bomb on him on the 12th, and then she follows up with him on the next day. And this is what it says. Attaches a draft of the motion that we are likely filing tomorrow. Motion outlines the information we uncovered about the alternative suspects. I'm happy to share with you the status of the investigation as we move forward. Of course, if you have any questions, please do not hesitate to reach out to me at any time. Mr. Lee replied to Ms. Feldman's email later on September 13th. 5 minutes. What do you mean? Oh my God. Have I been talking and like it's my new mic? I think if I touch, can you hear me now? Can you hear me now? Yeah. See, it's my new mic has this thing right here. I like can't forget about it. If I touch it, that mutes it. Oh wow. I won't touch the mic. I won't touch the mic. Wow. I'm glad I finally looked up. I would have been super pissed if I had read for like a half an hour and you guys are like, yeah, we didn't hear a word you said. Wow. All right. All right. So we're all the way back up at the email. Okay. All right. So which part of the email? Which part of the email? So I'd say I'll just start with her email to Mr. Lee. Okay. Does that sound about right? Oh, so you heard the September 12th. Okay. All right. So here's the email. So this is from Feldman, the prosecutor, to Mr. Lee, Hae Min's brother. So attached is a draft of the motion that we are likely filing tomorrow. The motion outlines the information we uncovered about the alternative suspects. I am happy to share with you the status of the investigation as we move forward. Of course, if you have any questions, please do not hesitate to reach out to me at any time. Mr. Lee replied to Ms. Feldman's email later on September 13th. To be clear, as a family, we disagree with your course of action and stand against the motion to vacate judgment. Sick. That's because he put an E in there. Just so you guys know, one of the first things they hammer home with you in law school is that there's no E in the word judgment. There you go. Spelling lesson for the day, kids. All right. We believe that there is overwhelming evidence and that the court convicted the right person. I hope you understand the emotional turbulence this trial is causing us. It seems that there's never an end to it, but we understand your position as an attorney to do due diligence and cover all possibilities. On September 14th, Ms. Feldman replied by email. I very much understand your family's position. I am so sorry for the pain this is causing you. Ms. Feldman, quote, promised to keep Mr. Lee updated with all the new developments. Yeah, that's correct, Katie. Judgment. The state's attorney, through Ms. Feldman, filed the motion to vacate Mr. Syed'S convictions in the circuit court for Baltimore City on September 14th of 2022, the vacatur motion. In the vacatur motion, Ms. Feldman asserted the state's attorney's office had received new information after the entry of Mr. Syed'S judgment of conviction that called into question the integrity of the conviction and that the state therefore was proceeding under CP, the newly minted statute 8-301.1 A1 II. Specifically, Ms. Feldman represented that the parties had uncovered Brady violations with all new information, all concerning the possible involvement of two alternative suspects. Additionally, the parties have identified significant reliability issues regarding the most critical pieces of evidence at trial, end quote. With respect to the alternative suspects, the motion recited, the parties have developed evidence regarding the possible involvement of two alternative suspects. In the state's reinvestigation of this matter, new information was learned about these individuals that suggest motive and or propensity to commit this crime. However, in order to protect the integrity of the ongoing investigation, the names of the suspects, which suspect in particular, and the specific details of the information obtained will not be provided at this time. The motion further explained the state located a document in the state's trial file, which provided details about one of the suspects. A person provided information to the state that one of the suspects had a motive to kill the victim, and that the suspect had threatened to kill the victim in the presence of another individual. The suspect said that he would, quote, he would make her disappear, he would kill her, end quote. The state also located a separate document in the state's trial file in which a different person relayed information that can be viewed as a motive for that same suspect to harm the victim. This information about the threat and motives to harm could possibly have provided a basis for the defense to present and or bolster a plausible alternative theory of the case at trial. And I said this the first time when I was muted, and I'm going to say it again, except in Judge Gall's court. There you wouldn't get to bring it in. Due to the ongoing investigation, further details of this information will not be provided at this time. You guys talking shit? Like, I can't, like, I mean, why would they put something right there on the mic that is like touch thing? I mean, I guess it's handy if I get used to it. I completely forgot it was there. Oh, I'm so glad I looked down. I don't even know why I looked up. I'm just so, because Dizzy is a genius. Because Don Burke was kind enough to throw a $10 hollow and tell me that I was muted. Don Burke's the hero of the day right now. I'm telling you that. Thanks, Don. I appreciate that so much. All right. So the information about the threat and the motives to harm could have possibly provided a basis. Just want to make sure it's to present and or bolster a plausible alternative theory of the case at trial. Due to the ongoing investigation, further details of this information will not be provided at this time. Okay, so the motion stated that, quote, considering the totality of the evidence now available, the information about an alternative suspect would have been helpful to the defense because it would have helped substantiate an alternate suspect defense that was consistent with the defense's strategy at trial. Ms. Feldman further recited that in 2022, the state's attorney's office discovered that, quote, through the investigation of property records and other media, that the location where Miss Lee's car was found in Baltimore City was known to one of the alternative suspects, that a, quote, person related to the family, end quote, owned a house near that location for many years, and that, quote, that person lived at that location in 1999. In addition, according to the motion, the defense, quote, located formerly documented evidence unavailable at the time of trial that one of the suspects had, without provocation or excuse, attacked a woman unknown to him while she was in her vehicle, end quote. The state further recited that this incident occurred after Mr. Syed'S trial and that and that the suspect was, quote, convicted of this offense, end quote. Further, the motion stated the parties had obtained credible information that one of the suspects had engaged in multiple instances of rape and sexual assault of compromised or vulnerable victims in a systemic, deliberate, and premeditated way, or systematic, sorry. And that, quote, the suspect was convicted of this offense, which also occurred after Mr. Syed's trial. So, like, again, when I was reading this back when they filed it, and what ended up happening, if like we were a much smaller YouTube channel then than we are now, but when we covered it, like I can't remember if it was just I don't even think we were able to cover that. I think that we had to cover the hearing, the appellate court, the argument. So, like, what ends up going on in that hearing, the vacatur hearing, is they just stand on their pleading, meaning that they don't argue. They don't flesh any of the stuff out. They don't flesh out the Brady violation. They don't get into these alternative, like, and again, they say why they're not getting into who the alternative suspects are, but like after I read this thing, I'm like, man, I'm like, they're actually gonna make another arrest. I'm like I thought that there was, like, in my mind, like we'd all heard for 10 years post serial what all the arguments were with respect to why Syed is innocent, right? And none of that had seemed to compel the courts because essentially the same arguments were being made by the lawyers. So when I read this, which again was filed by the prosecutor's office, that's what make this is so different than anything else. This is filed by the prosecutors, not the defense attorneys. Don't ever forget that part of this puzzle. And but like I'm sitting there with Allison, I'm like, my God, like they have to make an arrest, right? Like they've got somebody lined up on this. And it just like it never happened. Which just like I'm wondering, I'm like, it surprised me, frankly, that they vacated it without having somebody else lined up. Because like that's a much easier thing to tell a victim's family, like, look, we're vacating it because we got the right guy. like this guy was the wrong guy. We found the right guy, and this is what we got on him. It's like that's a way, way easier conversation to have with them. And that just like it never took place. Okay, so the motion further stated the defense located formally documented evidence of allegations that one of the suspects had engaged in aggressive and or violent acts toward a woman known to him and forcibly confined her. It was also alleged that the suspect made threats against the life of this person. According to the motion, quote, these events happened prior to trial in the case, and this information was known to the state. Given the circumstances of Miss Lee's death, this evidence would have been consequential to the defense's theory of the case, end quote. The motion also recounted that the police had improperly cleared one of the suspects in the course of the initial investigation as a result of errors in administering and interpreting polygraph tests that were administered to the suspect. The motion also pointed to discrepancies between Mr. Wild's statements to police and his trial testimony and expressed concerns about the reliability of the incoming cell phone records upon which the state had relied at trial. Now, that was one of the things that, and that continues to be one of the things about this case where, people that are covering this case and arguing about innocence or guilt are acting as if these cell phone records were, uh, that they were completely reliable in terms of the technology back then. I just disagree. I just don't think that the technology back then, in terms of triangulation and being able to pinpoint somebody's location, were even close to being enough to convict somebody on. And it was like you've got cell phone records that are, cell phone data that's spurious at best in 1999, 2000. And then you've got a habitual liar. Jay Wilds on the stand, like, I don't know, I don't know. The motion made clear that the state's attorney was not then asserting that Mr. Syed was innocent, but rather that it no longer had confidence in the integrity of the convictions and that at a minimum, that Mr. Syed at a minimum should be afforded a new trial. So later on September 14th, so that gives you kind of the heart of the motion, right? Okay. So later on September 14th of 2022, Mr. Syed filed a response to the vacatur motion in which he joined in the state's attorney's request for relief. All right. Um, so the September 16th hearing in the court's chambers. So on the afternoon of Friday, September 16th, so 4 days after young Lee was given notice that this thing was going down, they have this hearing. Okay. So on the afternoon of Friday, September 16th of 2022, the circuit court held an off the record in camera hearing in the court's chambers. Ms. Feldman and Ms. Suter were present at the hearing. Mr. Lee received no notice of the in camera hearing and consequently did not request to attend it. At the in camera hearing, Ms. Feldman and Ms. Suter provided the court with copies of the two documents that the state's attorney's office believed contained Brady material, neither of which was included with the vacatur motion or otherwise placed in the record. The record indicates that the date and time for an in-court hearing on the vacatur motion the following Monday, September 19th at 2 p.m. was also set during this hearing in the court's chambers. So the prosecutor's communication with Mr. Lee following the scheduling the September 19th in-person hearing. So at 1:59 p.m. EDT on Friday, September 16th, immediately following the hearing in chambers, Ms. Feldman emailed Mr. Lee. The court just scheduled an in-person hearing for Monday, September 19th at 2 p.m. It's an in-person hearing, but I asked the court for permission for you and your family to watch the proceedings virtually if you would like. So if you would like to watch, the link is below. Please let me know if anybody from your family will be joining the link, so I will make sure the court lets you into the virtual courtroom. Please let me know if you have any questions. Mr. Lee did not respond to this email. Because Miss Feldman did not receive a reply from Mr. Lee, she texted him at 1:22 p.m. on the afternoon before the hearing, which was Sunday, September 18th of 2022. Just wanted to make sure that you got my email about the hearing scheduled for tomorrow. I sent a video link in case you want to watch. Mr. Lee responded to Ms. Feldman's text at 4:08 p.m. on September 18th. Yes, I got the email. I will be joining. Thank you. So in the meantime, what Mr. Lee's really doing is calling a whole shit ton of lawyers, trying to find a lawyer that's going to help him. And he does. So at approximately 6 p.m. EDT on Sunday, September 18th, Mr. Lee retained counsel in connection with the vacatur motion. On Monday, September 19th, Mr. Lee's attorneys entered their appearances in this case. At the same time, Mr. Lee, through counsel, filed a motion for postponement and a demand for rights. In his motion, Mr. Lee requested that the vacatur hearing on the vacatur motion be postponed 7 days to allow for him and his family to travel to Baltimore from their residence in California. Mr. Lee explained, based on the potentially dispositive nature of this hearing and the right of the victims and surviving families to meaningfully participate in such proceedings, the family wishes to be physically present at the in-person hearing. The notice provided was patently insufficient to permit that to happen. Mr. Lee also asserted that even if he and his family had been able to attend that day in person, that they, quote, could not meaningfully participate in and be heard, end quote, because Ms. Feldman had not disclosed the factual basis supporting the vacatur motion, and because the motion did not name any alternate suspects. The September 19th hearing. So this is when it all goes down. On the afternoon of Monday, September 19th, the circuit court conducted the in-court hearing on the vacatur motion, also known as the vacatur hearing. Mr. Syed, members of his family, members of the press, and spectators attended the vacatur hearing in person, as did Mr. Lee's counsel, Stephen Kelly. Mr. Lee did not attend the hearing in person. After the court was called to order, the court asked Mr. Feldman to state specifically what notice the state had gave to the victim's family in the case. After explaining that, quote, counsel and I met with the court on Friday, and the hearing was scheduled for today. Ms. Feldman advised the court of her communications with Mr. Lee by email and text on the preceding Friday and Sunday. She also explained that she provided Mr. Lee with a copy of the vacatur motion prior to its filing. The court subsequently asked Ms. Feldman, now, attendance, as far as your understanding from the victim's family, the attendance was going to be done how? Ms. Feldman responded. So I did not know until he texted me back yesterday whether he was going to attend via Zoom, and he indicated that he would. He had not indicated to me that he had wished to travel to be here today. The court then asked Mr. Lee if Mr. Lee was on the Zoom, and hearing no response from Mr. Lee, the court then heard from Mr. Kelly. He asserted that the notice given to Mr. Lee on Friday afternoon was patently unreasonable and that it provided no opportunity for Mr. Lee to be present. Mr. Kelly also objected to Mr. Lee's lack of, quote, meaningful participation in this proceeding, end quote. Mr. Kelly further complained about the state's, quote, failing also to give any kind of notice as to what it is that has caused the concern on the part of the state's attorney's office. Regarding the validity of Mr. Syed's convictions, Mr. Kelly reiterated that Mr. Lee was seeking a 7-day postponement so that Mr. Lee could attend the hearing in person and meaningfully participate in the hearing. To me, this is where it all went to shit. Like, if I'm Erica Suter, I'm going to Syed and I'm saying, look, this dude wants like 7 days to come out here and be present. You know, I mean, look, I know, and again, you have to be presupposing the judge is just granting this thing. It's like somewhat presumptuous to just assume that the judge is going to be cool with it. But obviously, you know, the in-chamber hearing, again, like I don't know that we ever found out uh, I mean, what was actually shown to the judge in chambers, I mean, it must have been very compelling. I mean, we heard some of the Brady material in the motion for the vacatur, but like, like I'm going to him like you've been in for 20 plus years. Like we don't want anything to screw this up. Like we've got the victims, like the families, like they're upset. They're filing things. Like we don't want them filing things in this case. We don't want them. Let's allow them to be here. Let's allow them to say words if they want to say words. That's what I'm doing. And I get it. Like in that moment, like they're probably so excited because the fight's been so long to try to right this perceived wrong that they're like, wow, man, you're gonna be out and like making promises. You're gonna be out, you're walking out of that courtroom today, a free man, and like this happens. I mean, at this point, Syed's like going to Georgetown. He's got some kind of I don't know if he's actually a full-blown lawyer, but he's got a lot of education in the process and understands how it works. And it's like just all around, like from and it's gonna like as this proceeds, you're gonna see like this and anybody just pointing their fingers at the court and the defense attorney are full of shit. This is like all of them, like especially the prosecutors. I mean, it's their motion. That's not sufficient notice. Like you got to let people know what's going on. You got to let victims' families know what's going on. Like 2 days before you file something like this, in my opinion. Like Syed's paying the price. I mean, there is a distinct possibility that he ends up back in prison with convicted. I mean, I know the that's not what people want to hear that are of the mindset that he's innocent of this and should be out. But I mean, that's facts. Like anybody who's not saying that, I don't give a shit what side you're on, is not being intellectually honest. They're not being honest about what could potentially happen here. Like, I mean, the world that we live in is not puppy dogs and ice cream. I mean, it's like it's brutal. Like in given young Lee 7 days, none of this is happening. This was so easily avoided. That's the one thing that I agree on. But I was saying that a long time ago. Like say, give the guy the 7 days. Gives a shit. 7 days for decades. It's just, ugh, man. Oof. So the court responded by noting that the electronic proceedings are allowed in the circuit court for any circuit court, and we do them here every day. The court continued. I was told that Mr. Lee lived in California, that he would be present by Zoom. Now it appears that since Friday, Mr. Lee has changed his mind and he wishes to be present here in Baltimore City for this hearing. I mean, Zoom ain't it. I love Zoom for status hearings. It's great. Saves my clients money, saves us time. But like should never be doing substantive things. Yeah, I don't care, Mr. Crowley. Common sense and decency. Like you give the 7 days. The point is he would have been there. He wouldn't have filed the appeal. That's what you're missing. You're missing. What he would have said in court would have not affected anything. That's the point. And now, because he didn't do it, this thing went all the way up the chain, all the way up to the Maryland Supreme Court. This is a losing argument, Mr. Crowley. With all due respect, you give the 7 days. You give the 7 days. We're not here. I'm not on this live reading this thing right now. It's as simple as that. It is as simple as that. Like that, like seven to like whatever you're arguing here. It doesn't have anything to do with constitutional rights at this point. It doesn't. I'm just telling you, this is a different issue. This isn't even dealing with Syed's rights at all. It's my entire point. This whole thing is about the victim's rights. That's it. You don't have a constitutional right to have the state file a vacatur motion. It's not a constitutional right. Like, I mean, explain to me what you mean, and maybe you can get me off. Like, I'm just telling you, they should have given him the 7 days. Wait, I said it then, and I'm going to keep repeating it. You give him the 7 days because who cares after 20 plus years? Nothing, like, he wasn't going to go into court and change anything. Like, it's just he would have said his piece. The judge had already apparently made a decision that she was going to be vacating it. So to allow him to come in and say his piece, the family would have at least had that, and then appeals aren't being filed. I No one's convincing me on the other side of this thing, man. Like, that should have just absolutely. It's not about like, quit saying 7 days is not legally established. Right? It's reasonable. It's what's reasonable. It's what's reasonable. That's what he asked for. 7 days isn't the notice they were given. I mean, he was really given. I consider when he's given the unfiled copy of the motion kind of notice, he was really given 3 days notice that the hearing was set. That's the reality of it. Either way, that like your argument is, I don't know. It's I mean, I like, I'm a defense attorney, dude. I get it. I get it. I'm just telling you, if I would have been repping him, Syed, I would have said, dude, we're giving him the 7 days because like, I'm not doing anything to mess this thing up. I'm not doing anything to mess this thing up. And this is where we're at. Like, the proof is in the pudding. You could see that this thing was going, like, if you know anything about the history of this case, and you can see what the Maryland Supreme Court has thought about this case prior to, I would have done everything in terms of, he was granted new trial. Maryland Supreme Court back in the day said, nah, we're not feeling it. You know what their position is, what their posture is on this. You're avoiding. You should go back and listen to our old lives. It's we were spot on all of it. I mean, you avoid, if you're Syed's attorneys, you avoid the Maryland Supreme Court like the plague, and they didn't. So, but you can keep going on arguing about 7 days all you want. This is your end result with that argument. So Mr. Kelly then confirmed that Mr. Lee would travel to Baltimore for the hearing if it were postponed for 7 days, after which the court stated, wait a minute, are you not aware that by him telling us on Friday that he was going to appear via Zoom is why we set this hearing today? Because had we known that on Friday, of course, we would have scheduled this hearing according to when he was planning to arrive within a reasonable amount of time. So he didn't do that. Now that's the court. That's the court saying that. Mr. Kelly responded that Mr. Lee did not state on Friday at any time that he would participate, unquote. Mr. Kelly acknowledged that in a text to Ms. Feldman at 4:08 p.m. on Sunday, Mr. Lee had said that he would participate by Zoom. But Mr. Kelly continued, that was shortly before Mr. Lee retained Mr. Kelly to represent him. Mr. Kelly observed that Mr. Lee is not an attorney and he has every right to be counseled by an attorney as to his rights, and then act accordingly. So the circuit, so this is, again, Mr. Kelly is young Lee's lawyer. Okay, just so you're not losing the focus here. Okay, and so the court responds, well, you did see the confusion, right? Mr. Lee told the state through text that he would participate by Zoom. Now, counsel and I have been in close communication about this case procedurally since Friday. So he had told Ms. Feldman that he didn't want to participate via Zoom and wanted to be in person. Oh, so had he told Ms. Feldman that he didn't want to participate via Zoom and wanted to be in person, so she would have communicated that with me, and then we would have taken the appropriate steps. So Mr. Kelly then asserted that what Mr. Lee had received was not adequate notice under Maryland law. So the court replied, nothing says that it has to be a particular time period. Here's Mr. Crowley's argument. It says notice in 8-301.1, which is the statute for motion to vacate. It says notice. It doesn't have anything about reasonable notice. Mr. Kelly responded that, quote, reasonableness is a standard that's been long applied by the Maryland Supreme Court, and reiterated that, quote, 1 day's notice is not adequate, end quote. According to Mr. Kelly, Miss Feldman had an affirmative obligation to apprise Mr. Lee that he had the right to participate in the hearing beyond observing, and that she failed to do so. Mr. Kelly further argued that under CP 11-403, Mr. Lee had a right to speak at the hearing. The circuit court disagreed, stating that 11-403 has to do with the sentencing or disposition hearings. That's not what this is. This is a motion to vacate. The court denied Mr. Lee's motion for a postponement, but allowed Mr. Kelly time to have Mr. Lee join the hearing by Zoom. Mr. Kelly then called Mr. Lee, following which he reported to the court that Mr. Lee was at work, but that would just request 30 minutes to get home and to a private place where he could participate. Court granted that accommodation and recessed the hearing. Proceedings resumed 50 minutes later. At that time, the court said to Mr. Lee, who was watching the proceedings by Zoom, you're here today to make a statement, and the court is ready to hear from you. Mr. Lee thanked the court for the opportunity to speak, and then described how he had been, quote, living with this for 20 plus years, and every day when I think it's over, it always comes back. It's not just me killing me and my mother, and it's really tough just going through this again and again and again. It's living a nightmare over and over again. He said that he believed that the state had done a, quote, fine job of prosecuting Mr. Syed, and that he, quote, always thought the state was on his side, but now felt, quote, betrayed by the vacatur motion. He further stated that he was not, quote, against an investigation, end quote, but that the vacatur motion was, quote, really tough for him to swallow, end quote. Mr. Lee noted that he wanted to make his statement in person, but he didn't know that he had the opportunity. So after Mr. Lee finished speaking, the court said that it was, quote, mindful how difficult this day is for you, end quote, and that it appreciated Mr. Lee, quote, joining by Zoom this afternoon to make this statement because it is important to hear from the victim or the victim's representative, end quote. After Mr. Lee thanked the court, Mr. Kelly requested permission to, quote, just say a couple of sentences. The court declined Mr. Kelly's request, stating that it did, quote, not think that it's appropriate at this time, sir. We've heard from the victim, and I heard from you earlier. The court then said it was, quote, satisfied that all the requirements under criminal procedure 8-301.1 have been met by the state. Therefore, the hearing will commence now. Court then heard from Ms. Feldman. In addition to repeating the information contained in the vacatur motion, Ms. Feldman stated that what is unusual in this case, unlike all of the other motions to vacate my office has filed in the past, is that this motion should be granted. We will be continuing our investigation. We will not be asking this court to dismiss the case at this time. Instead, we are requesting that a trial be set in. The state's ultimate decision to proceed with a new trial or ultimately dismiss the case is contingent upon the results of the ongoing investigation. However, the state is requesting the defendant be released on his own recognizance pending the investigation, should the court grant this motion. Ms. Feldman did not introduce into evidence the alleged Brady material that the parties had provided to the circuit court during the in-camera hearing on September 16th. Yeah. After Ms. Souter made brief remarks, because that was the thing the appellate court said. The appellate court, when they before it got kicked up to the Supreme Court, the appellate court was like, nah, go back and do it again. Like, you're like, we're vacating it. We're vacating the conviction. You're going to go back. You're going to do it right. Including, you're going to put on an actual hearing. You're going to put witnesses on the stand. It's going to be an adversarial proceeding, period. That's what you're doing. And the Maryland Supreme Court agrees, because this thing where she just goes in and reads her pleading and stands on her pleading was not sufficient. Not in the eyes of the court, not in the eyes of the high court, especially. Um, and it's just like, I don't know. I don't know. Uh, Just had to give him the 7 days. It's just crazy. It's crazy. Like, if I was Syed, I would have been like, give him the 7 days. Like, we're gonna blow this whole thing up because like a week. I don't know. Like, everybody arguing about the semantics of it. Like, at the end of the day, this is what you get. There is no alternative argument for this. There just is no alternative argument to this. I mean, this could be a nightmare for him. Like, and I've been warning people, anybody who'd listen, including Kaboom Blam Zoom. Um, After Ms. Souter made brief remarks, the court read the text of an order granting the vacatur motion. Next, the court stated, at this time, we will remove the shackles from Mr. Syed, please. After a pause to allow the unshackling to occur, the court continued. All right, ladies and gentlemen, it is my understanding that the state and all counsel will hold a press conference outside the courthouse this afternoon. So I will, at this time, excuse the press to go down first. End quote. After the press and spectators left the courtroom, the court directed a person who was present in the courtroom to apply an ankle transmitter to Mr. Syed for purposes of electronic monitoring. The hearing then concluded. The court entered a written order granting the motion to vacate. The vacatur order later in the afternoon of September 19th. The vacatur order stated in part, upon consideration of the papers, in-camera review of evidence, proceedings, and oral arguments of counsel made upon the record, the court finds that the state has proven grounds for vacating the judgment of the conviction in the matter of Adnan Syed. Specifically, the state has proven that there was a Brady violation. Why did you put it on the record? Put it on the record. Put it on the record. Additionally, the state has discovered new evidence that could not have been discovered by due diligence in time for a new trial under Maryland Rule 4-331C. It creates a substantial or significant probability that the result would have been different. So the vacatur order further stated that Mr. Syed was released on his own recog and placed on home detention with GPS monitoring. The vacatur order also directed the state shall schedule a date for a new trial or nollie pros of the vacated counts within 30 days of the date of this order. So then we got number 3, Mr. Lee's notice of appeal and motions to stay. So on September 28th, mere 12 days later, Mr. Lee noted an appeal on the vacatur order. On September 29th, Mr. Lee filed in the circuit court a motion to stay the proceedings in the circuit court pending appeal. Mr. Lee also filed a motion in the appellate court of Maryland to stay the circuit court proceedings pending the appeal. On October 6th of 2022, Mr. Syed filed a notice in the circuit court stating that he intended to file a response to Mr. Lee's motion to stay on the 4th. So what they're talking about here is, so after this went down, there was a date set. So they had 30 days to decide whether or not they were going to retry him or they were going to dismiss the case, nollie pros it. All right. And so Lee's attorney ran in, filed this thing. He wanted to stay that court date, wanted to push it. Stay means just hold it in place, delay it. And I don't think I am, Kaboom. I don't think I am. But I do love you. I know you're passionate about Syed. So in this one, though, they shit the bed. They shit the bed. I told you this is what I was worried about. I told you this a year ago. Said all this shit. This is like worst case scenario. Going up to the high court, a court that has shown no sympathy for Syed show no inclination to believing that he's not guilty, and that's where you end up. The law is like chess. This ain't checkers, and I know Erica Suter's a hell of an attorney. And I know that he's had great attorneys working on this case. And this one was just misplayed. But again, like it's easy for me to armchair quarterback it sitting here being like, oh, yeah, if I was sitting there, I would have said, let's do the week. Maybe I'm so excited for him. I'm like, I mean, the court's going to push it through. Should we just say screw it? You know what I mean? Like, it's easy for me to do that. So, like, I just think that I would have been like, dude, let's give him the week. Let's just give him the week. Let's give him the week. I mean, if they gave him the week, we're literally not here. We're literally not here. All right. So, okay. So again, the state's got the 30 days to shit or get off the pot. We're either going to retry him or we're not like processing the charges. So after Lee files his appeal and the motion to stay the proceedings, wherein the state's got to come up with what they're going to do, the state runs in on October 11th and says that after DNA testing of items, Mrs. Lee's clothing yielded a mixed profile from which Mr. Syed was excluded as the contributor. State's attorneys entered a null process of Mr. Syed's vacated charges. So they nolly process on the 11th. So that first point that they were talking about when we first started this live a couple hours ago was talking about whether or not the nolly process mooted Mr. Lee's filing, and the court has said no, it didn't. What it did is it moved back the hands of time. Now we're in a place that the vacatur motion, the petition for the vacatur of the commission has just been filed. So that's where we're at. It's like judges can file what they call non-pro-tunc orders, where they kind of go back and they put something in the order as if it really happened on the day that order was drafted. So it's going back in time, and the court's like, no, so it's not mooted. Like, this is like he would have had the opportunity to file the appeal had he been given more notice at the time that you told him that you were filing this petition. He could have said, I think it's bullshit. I'm filing an appeal. I'm going to file something. I'm going to get a lawyer. I'm going to file something. So that's where the court's at on that one. So 5, on October 12, the appellate court denied Mr. Lee's motion to stay and ordered Mr. Lee to show cause why the appeal should not be dismissed as moot. The parties filed responses to the show cause order, and on November 4th, 2022, the appellate court ordered that the appeal would proceed. Okay, the appellate court subsequently issued a reported opinion in which it vacated the vacatur order, reinstated Mr. Syed's convictions, and ordered a new remand for a new vacatur hearing. So that's where they were at. That's where the appellate court was at. All right. And pretty much the high court is in lockstep with them, other than they're giving him this ability to speak on the merits, which I honestly don't know what that means. Because he's not a party, so he can't introduce, to me, I think what they're saying is that he can just come in and say that I think that everything that they're saying is wrong, because he's not a party, so he can never introduce, the victims can't introduce evidence. They're not parties to the action. So I think it's kind of like he just like victims' families can give opinions on whether they think that something is righteous or not righteous, and give reasons why they don't. I don't know. It's not a situation where they're going to come in because I can sense that some people in the chat are like, well, they can't go in there and litigate. Well, they're not going to litigate. That's not what they're doing. Um, you think? I don't know if that's true. I don't know if that's true. Like, for what purpose? Like, because like, it would have been a completely different appeal. Like, if they had given it, like, what would the appeal have been? Like, you think they would have appealed just the entry of the vacator order? I don't know. Maybe. I mean, they didn't really even address it in this appeal. They just went straight for the victim's rights stuff. Really? Yeah, but for what purpose? I always love chatting with you. Actually, we always have spirited debates, and we're really both on the side of justice. So like, I got no beef with it. Um. All right, so I'm gonna skip past what they did down there. All right. Okay, so once they ask for certiorari again is when you're asking the Supreme Court, whether the U.S. or the state, hey, would you take a peek at our case? Take a look at it. We want the Supreme Court to weigh in on it. All right, so there were cross petitions filed. So Syed's lawyers filed, Lee's filed. So they've got crossing petitions, and these were all the grounds. So between the two petitions, we agreed to review the following questions, which we have reordered and rephrased. So, one, did the entry of the Nolly Pros moot Mr. Lee's appeal of the vacatur order? We know what the answer is to that. Does a victim have the right to be heard at a vacatur hearing? 3, does a victim have the right to attend a vacatur hearing in person, or does remote attendance satisfy the right of attendance? 4, did Mr. Lee receive sufficient notice of the vacatur hearing? And then 5, must a victim who seeks reversal of an order of due court to violation of the victim's rights make a showing of prejudice? And if so, did Mr. Lee do so in this case? And then so Syed's petition for cert was asking these questions be reviewed. Does a lawfully entered nollie pros render moot an appeal alleging procedural violations at a hearing occurring prior to the nollie pros? So it's basically the same question as their one, just wordier. So 2, does a victim's rep, a non-party to a case, have the right to attend a vacatur hearing in person, or does remote attendance satisfy the right? So again, basically the same question as 2. 3, was notice to the victim's rep of the vacatur hearing sufficient, where the state complied with all the statutory and rules-based notice requirements? Again, same thing. And then 4, must a victim's rep seeking reversal show prejudice on appeal? And then so Mr. Lee's cross petition for cert sought review of the following question: whether victim's right to speak as enshrined in Maryland's laws and Constitution is incorporated into the vacatur statute, where no party or entity other than the victim has an interest in challenging the evidence alleged to support the vacatur. All right, so then you're getting into the meat of it. I'm 2 hours in, and I'm tired of reading. I think I'm like 37 pages in. So what I think I'm going to do, I want to take some questions now, read some comments, argue with some people, I'm sure. And then tomorrow, I'm in Stone, Delphi. I got to do Delphi. I'll drop that order today. And but I want to have Allie. Allie was babysitting today, so that was really why I didn't push Adnan to tomorrow. So I'm going to do Delphi tomorrow, and then maybe like an early evening back up on Syed, like finish this thing out, because I do want to get into the arguments and I want to get through some of the dissents with you guys. So if you've got questions, now is the time to ask them. I'm going to start here. Well, first of all, thank you, Meg P. Always giver, always, always, always given. Gifted 10 DD memberships. Appreciate you so much. Gifted another 5. Wow, you're amazing. Love you, Meg. Thank you for all you do. Joanne, love you. Bob and Allie, glad to be a member of this family. We are so glad that you are. We adore you. Jennifer Hill, Bob Motto. Young Lee was able to attend the hearing via Zoom and gave a lengthy statement, which he wasn't necessarily allowed to do, is my understanding. Yeah. I could just tell you, like, and I know I got kind of cut off. I started reading comments, which always sidetracks me, but I can tell you this. Zoom court is not real court. Like, there should never be substantive hearings or there's witnesses involved via Zoom ever, in my opinion. You need to be there in person. I could tell you this. If one of my family members was murdered by somebody else and they were having this type of hearing, you bet your ass I'd be there in person. I mean, put yourself in somebody else's shoes, like all the hand clutching and the just put yourself in other people's shoes, people. Like 7 days is reasonable. Like no one's ever changed my mind on that. Like should have been kicked. Kick the can down the road for 7 days. Zoom thinks that they would have filed an appeal anyway. I don't know that. I don't know that they would have. I mean, if they would have been able to say their piece right there, I don't know that they would have been appealing. Honestly, they're not a party. Like they appealed the things that they could appeal because they have victims' rights. That's what they were appealing were violated. Like what you can't just appeal things because you want to appeal things. You have to have a grounds, a basis. They're not a party. They wouldn't be able to challenge. Yeah, I just agree with you or completely disagree with you. I mean, I don't think they would add anything to appeal, nor the standing to appeal. So there's that. Yeah, I disagree, Jennifer. I think that Zoom is suck bag world. It's like, it's not how you conduct hearings like this where people's lives have been massively affected. You allow people to appear in person. You give them ample notice. Like what like we're not talking about like a month. Oh, I want 60 days. It's like a week. I want a week. Give me a week so I can make arrangements to fly my whole family out there so we can sit in the courtroom and watch you free the guy that you guys promised me was the right guy. My whole family. And after 20 years, you're saying it's not the right guy. Like, I don't know. When people say that they don't think that that's like the way it should have gone down, I have to question your humanity a little bit. I'm an empath. I am a defense attorney through and through, courses through my veins, but I'm also very empathetic to people. And I just think that it was a no-brainer. In the face of what looks like prosecutorial caused issues, does Adnan have any rights to appeal or sue? It seems that the state has treated his life cheaply and continues to do so. I mean, all right, so let's talk this out. All right. And in my world, worst case scenario for Syed is that the successor to Mosby thinks that this entire vacature petition was a steaming pile of shit and that he's not on board with it. So now the question becomes legally, is there any way for Syed's attorneys? Because what I'm saying is he could just withdraw the motion, the petition. It wasn't filed by him, it was filed by his predecessor. I mean, I don't know that there's anything that's stopping him from saying, you know what? I don't agree. I know that my predecessor was about it, but I'm assuming that Feldman's still in there. I don't know, honestly. I'm assuming that Feldman's still in that office and that she's working the new the new boss and being like, yo, like, you're not gonna back out on this thing, are you? Because it's like if that happens, I mean, all they can really do is go to the federal system. Like, they have gone to the highest court in Maryland now. And whether or not I don't know that the Supreme they've already denied cert on different issues, obviously, of this case once before, the US Supreme Court. I don't know that it's messy. It's super messy. It just is like if you're of the Syed'S guilty camp, you're pretty happy about what's going on right now because there exists the very real possibility that this thing doesn't go down. Like, because the alternative is going to be, um, I mean, they're going to have to go in and have a full hearing. That is without question. Like maybe I'm hoping for the like for a lot of reasons that we get to hear what the actual Brady violations were. Like what I mean, they showed the judge something back there that had the judge like, "Oh, okay. All right. I'm with you on this." So there's got to be something there. But what they're I mean, they're absolutely forcing them to do this the full adversarial way, which is counterintuitive because you've got two parties that want the same thing. So really in this situation, even though they're not a party, the Lee family would be the only, but maybe if the Lee family is shown what they dug up, maybe they change their tune too. I just don't know what people are doing behind closed doors on this thing, and it just seems like there's like a lot of fumbling that's going on. I don't know. I don't know. I don't know. Yeah, I don't know. I don't know what they're gonna do with it, but so worst case scenario is the new prosecutor, new state's attorney of Baltimore County. Oh, is that what he's saying? He's saying he would release him when he ran for state's attorney in 2018. All right. Well, that seems like that he'll be on board. I think that should give Syed some hope. I mean, if you're Syed, you're living in like a horrible limbo world, kind of like what the Lees are living in. It's like no one's winning here. Like it's just a terrible situation for everybody involved. And had the right thing been done at the beginning, which again, I just think you give people the grace, you give them the compassion to just say, all right, yeah, just come on in. They're gonna say what they're gonna say. I mean, we can't forget. Like I tell you guys all the time, prosecutors and cops fill victims' families' heads with "We got the right person." Like that's it. They're never like, "Oh, well, maybe." Like they're no, we got him, we got him, we got him. So you can't sit in here and blame the Lees because they had it drummed in their skulls that they got the right person by the cops and the prosecutors. Like that's who you can thank. So they heard the evidence. They were like, "Oh, well, they don't. They're not lawyers, at least as far as I know." So, I mean, this is what you're going to get. This is what you get with victims' families. This is when you get, trials that go down where evidence isn't challenged. And, I mean, you're going to have family members that think that they 100% got the right guy. They want it to be the right guy. They need it to be the right guy. They want it over with. They want to move on as much as they can from like the process itself and just let the healing, whatever amount of that can actually happen, begin. And it's just never ending for them. Like I really feel a huge amount of compassion for them. I really do. And I feel it for Syed. Like if Syed's innocent of this, I feel like equally horrible for him. I mean, I mean, it's just like it's such a It's such a mess right now. Um, all right, so let's see. JD Lion, sup y'all. The thing I was confused about is does he go back to jail? Not right now. Not right now. His conviction, yeah. So what has happened? He is currently a convicted felon once again. Like that's where it's at. They have they they vacated the vacatur. Like that's gone. He's currently, as it stands right now, per the Maryland Supreme Court in stone, convicted of killing Hae Min Lee. That's it. That's where it's at right now. And you know, like I said, if you're Syed, you're not feeling great. I mean, and I'm sure he's got tons of people in his ear, being like, hey man, this thing's not great. I like I'm sure that they're telling him what they hope is going to happen, but reality is you never know with courts of law. You just don't know. It's uh it's not great. So yeah, the conviction's on his record. Whether or not he's gonna go back to jail is yet to be determined. He's out now, even though because they're waiting. I mean, there's gonna be more moves after this. What they are is it's got to go back for a hearing. So, but they told it's not going back in front of this judge, new judge. Like we're like, nope, we didn't like the way you handled that. So you are not going to be sitting on this. So it's going to go in front of a new judge. They're going to have an actual hearing, which I think I want to fly out there for. I actually want to be there for it. I want to be boots on the ground for that hearing because it's going to have to be a real one. Like there is no standing on the pleadings thing. No. So, Bugapoo, I hope that answers your question. He's not rearrested. He is still out. He's still out of custody right now. Chances that any of Adnan's hearings will be streamed so we could view it. I don't know. I don't know. Be nice. Be nice. I don't know what the situation is in Baltimore. We got any Baltimore folks out there? Any of our fam Baltimore or Maryland court observers, they can tell us whether or not I never see Maryland cases like streaming anywhere, so I don't know. I don't know. Spit. Why would the victim's family get to weigh in on canceling a conviction that was wrong? Well, I mean, it depends what do you mean, Megan, by weigh in? Like expand on that. Like why shouldn't they be able to say something? Like, I mean, are we afraid that they're going to change the judge's mind? If what a victim's family is saying, who is purely coming from a place of emotion, is going to affect a petition or emotion like this, then your shit's too tenuous to begin with. Like having the victim's family coming in and saying their piece should in no way, like if you're not coming in with a strong basis on this thing, like they got it wrong, and we're confident of it. If you're coming in, well, maybe, but like I mean, here even, I mean, Feldman's like, look, we're not even asking for, we're not saying he's innocent per se. What we're saying is he, at the very least, deserves a new trial. And then when they get those DNA results back, they decide to not only prosecute. Like we don't really know where the state's head's at. So, and just to boom, I mean, politicians say shit all the time. I don't like, and believe me, the elected prosecutor, the state's attorney of Baltimore County is an elected official. They say shit all the time. It's like the person that's running against Fani out there in their whole campaign is that, and I'm talking about the YSL. I just love that. I love that trial. Should be covering that. That the whole campaign is like The minute I'm elected, I'm dismissing that case. So, I mean, it's a pretty good platform. 'Cause a lot of people think that's a big, giant, stinking waste of money. I agree. I think it is. I really do. So yeah, like it depends on what you mean weigh in. Like they don't get to introduce evidence. I think that they should have the right to say, just say it's like when people are eligible for parole, like they always let victims' families come in. I mean, you can't be afraid to hear the truth, from what family members are like. That's their truth. That's their life. I don't think that. I mean, I guess the concern is that you're worried that people that are doing the decision making are going to be swayed emotionally by what people are saying into not following the law. I mean, I guess it's always possible. It's always possible, but all right. So Kraken, the way I hear is this: they're letting someone out of prison because they didn't do it. Well, that's not exactly what they said. They're letting him out because Uh, they don't think he got a fair trial, and then it turned out like I just read that portion where they're saying that they're not necessarily saying that they believe that he's innocent, but like I think we'd all feel a lot better if they arrested somebody else. I think that would cure a lot of the ills with this case. It would make the prosecutor's coverage of Adnan being guilty go away, so I don't have to watch them and Miller fighting in my feed. It's like, make an arrest for God's sakes. It's like, or are these two guys like really not that good of suspects? I don't know. So if the victim is not the victim of the person getting overturned, then how did the wait, let me read this again. So the way I hear it is they're letting someone out of prison because they didn't do it. So if the victim is not the victim of the person getting overturned, well, I mean, I hear what you're saying. I understand your concept, Kraken, but like if you follow the Syed case at all, you know that there are very differing opinions on whether or not he's innocent or guilty. Like I haven't sounded off on it one way or another, um, at all, other than to say that you know certain things that I've listened to haven't convinced me one way or another. But I'm hard to convince a shit. That's facts. Like like I'm a on the fence dude. I like really definitive evidence. But that comes with my trade. That's what I've done for a long time. I expect them to meet burdens which are very, very high. Deja, innocence investigations would it have made a difference if you were there in person? Would the ruling have been the same? Yes. So no and yes. It wouldn't have made a difference. He would have been there in person. His family would have been there in person. He would have said his piece, and she would have still nothing would have changed. That's my whole point. Like anybody who thinks that they're going to collapse because the young family is in person saying that we don't like what they're doing, we still think that they have the right person. And again, victims' families are told by law enforcement at the time of arrest of a person who's going to be charged with the crime that they have the right person. And then that's followed up by the prosecutor's office saying that we have the right person, feel secure in this. And then that goes on and on and on and on. And then it goes on through the appellate process where, the prosecutors continue to fight the appeals. Like they're dug in. They're dug in. It's the right guy. And then all of a sudden, boop, nope, wrong guy. All right. Crystal O'Neill, but didn't these corrupt cops and the other actors go to Lee and help him to file this, including finding his attorney who lives down the street from I have no idea, Crystal. That sounds like that's some deep state shit. That's not my game. I mean, maybe. You're asking the wrong dude. That's like I have no clue. I have no clue if any of that shit. From what I can tell, I mean, I could Google these attorneys. They're competent lawyers. I mean, they went up to the big court, the high court in the state, and that's it. All right, you guys keep referring to innocence investigations, but I'm not seeing what they said. Somebody throw up like what they're saying. So what did innocence investigation say? Like like you're throwing up half of the comments. All right. So Crystal says, or Mr. Crawley says, innocence investigations. Exactly. Lee and his lawyers are trying to make it about them. Oh man. Jeez. And not about the conviction of Syed. It's not about them. Sorry, but it's about Adnan's legal rights. Oh man. Dude, again, like I am like through and through defense attorney. Like through and through. I'm just telling you, like, how could you possibly know what the Lees are feeling? It's absurd for you to sit behind a keyboard and type anything even remotely like that. Have you suffered that type of loss at the hands of another person and lived it with it for 20 years? And until you've done that, for you to sit there and say that they're doing it to make it about them, it's tone deaf as hell. I'm sorry, man. Like, no offense. That's just my honest feeling on it. I mean, ugh, loss is real, y'all. Like, man, I don't know. I get the fight for justice. I get wanting to right wrongs. I get it. I do. But it doesn't have to be the expense of everybody else. It doesn't have to be at the expense of the victims' families. It doesn't have to be that way. Because this thing, what we're reading, has nothing to do with innocence or guilt. It's exactly what I started this live about saying. Boom. This isn't about that. That's a different thing for a different day. Maybe at the end of the day, were they was referring to why he would want to go to this hearing, but none before. Was referring to why he would want to go to this hearing. He'd want to go to the upcoming whenever they're going to have this hearing. Yeah, for sure. Like I would want to go to this one too. And like the last portion of like why I want to go to this hearing is to to hear the Lee's devastating victim impact statements or whether or not they think there's merits. I want to hear what Supreme Court hearing. This was all written. I don't know that they made oral argument on this particular. I think this was all briefs. And this thing is done. The Supreme Court has rendered its opinion. Like there is, this is it's they've mandated it. They've kicked it back down to the trial court. So, but what I was going to say is potentially, uh, I mean, maybe they just say you're gonna like we're gonna retry him. Which, if you're Syed, you were not loving that. You're not loving that. But I mean, like as far as I'm concerned, and I get that Kaboom is telling me that this new dude ran on the platform of that he would pardon Syed when he got elected or whatever. Them's just words. Like we'll find out. We'll find out if those words are what he meant or if them's just words. All right, so Afton Ford, gift of one DD podcast membership. Thank you so much, Afton, for everything you do. I adore you. I do. Megan. Spitfire. Does the prosecutor show the family new evidence? I'm not opposing them saying their piece, but the court already ruled that they messed that up. Well, who messed it up? The Lees didn't really mess it up. I mean, what they're going to have to do is have a full-blown evidentiary hearing. Yeah, that's the point. This thing, when it gets there, when we have the actual vacatur hearing, it's not going to be a lawyer just standing on their pleadings. Standing on your pleadings means, Your Honor, I've wrote out either in my actual motion or my memo of law our argument. I'm not gonna orally argue it in front of you because I just been repeating what's in my paper. So I'm standing on my pleadings. That's essentially what took place. I mean, uh, she read through her. She basically just read into the record what was already on the record because of the filing. There was no witnesses, or it wasn't a substantive hearing at all. Like that was one of the problems with that thing. So ultimately, this hearing is going to be the whole kit and caboodle. So because like we're not even to the point yet. So like when I say that we've gone back in time, we have now gone back to where the vacatur hearing has to be had. And if it's granted by the judge, then we once again have to wait for the state to either decide that they're going to prosecute him or not only, but it's a complete do-over of everything. So you guys understand, it's all getting done over. All of it. All right, let's see. Michelle J. Aw, so sweet. Thanks for reading much pages and explaining all of it. You are welcome, Michelle J. Thank you for hanging with us. Get a pretty decent crowd for a Wednesday afternoon. A little Syed. Oh, I'm telling y'all. Yeah, there are. Yes, but everybody gets to see it. It's going to be in a hearing. It's a full blown hearing. I hope I'm clear on that. It's called "We Own the City" by David Simon, 6-parter. Blow your mind. It'll blow your mind. It was literally one of the two reasons why this vacatur statute came to be. All right, let's see. Oh, I could tell Innocence is passionate. The Lees never attended these hearings, and they waited until the decision was made to vacate the conviction before they filed an appeal. Well, which hearings? I'm confused. There was only like which one? Which one? Like so like the vacatur statute, like that just happened. Like so they filed it. They were like we just read through it. They weren't given much notice. They were told 2 days before the state was filing to vacate the conviction that they were filing it. Like they gave them no heads up. It's like I don't know if you were late, but the way that it really works from the victim side of it, because there are, we have to remember the victims, right? We have to remember the victims. Taryn, come on. Wow, Taryn's over here firing. When will we get when I'm ready? Tomorrow? Why you bored of Adnan, Taryn? I mean, do I need to do a live with Delphi? Really? I mean, the reason I've slowed down is this thing is such a foregone conclusion. Like this is like a railroad job, the likes of which I've never seen. I mean, like we just read about in this case where they're talking about bringing these two alternative suspects where I'm not seeing any proof that they were in the car with Hae Min Lee, but they're talking about being able to bring this in at trial during Adnan's trial. Well, it's like, yeah, I'm kidding. Tomorrow, I'm doing tomorrow. Just busting butts. But I do want to get back to this. Like this is really interesting. Really, really interesting. It's really interesting. So, all right, I think I got to everything. Oh, okay. Let's see. Simply Bell, he made a statement at the hearing via Zoom. He knew prior that week that the hearing was occurring. So Simply Bell, he made a statement at the hearing via Zoom. He knew prior to the weekend that the hearing was occurring. So why didn't he file something? You got to find a lawyer. You got to like. I mean, Innocence Investigations. It sounds like you're deep into the whole true crime world. So I'm assuming that you know that Finding a lawyer isn't always the easiest thing to do. Paying for a lawyer isn't always the easiest thing to do. The people aren't doing shit on the arm. So they were given no time. He spent probably days calling lawyers, trying to find a lawyer who actually knew what the hell he was doing. Like, this isn't like some normal shit. Like, this isn't like, hey, I need you to file a motion to, try to stay a motion to vacate. It's like this is like some intricate pleadings. Like you're not going to get Joe Schmo with the shingle hanging over there by the way. Like, hey man, you want to go fight? It's like you need to have like lawyers that know what they're doing pleading wise and how to draft certain pleadings because these are not commonly pled issues. It's the fact. You're not going to be able to call your lawyer buddy. I'm not going to be able to call my dude who does like tons of pleas. Say, hey man, you ever done this? No, it's a brand new statute pretty much. So like, and no one's ever tried to, halt it. So I've never had to fight, so my point being, it's not much time. Like, I don't know how much he had to pay or the family had to pay for the lawyers and finding the lawyers. Uh, it's like you didn't want to give him 7 days innocence. Well, we're going to have to agree to disagree there. I think that 7 days is absolutely reasonable. Reasonable. And that's my opinion. Not gonna change it. All right. So I'm gonna call it right there. Solid 2.5 hours. You guys rock. Mods, you guys are amazing. Tonight, still don't know who I'm having on. It's been a challenging. We've had for my Dorsch night. I'm gonna see, like, I think we're trying to figure out who we're gonna have on. One of our two guests that was on the and you talk about some wrongful convictions. 44 of these people, of this filthy cop that I'm covering, Ronaldo Guevara, who put 57 innocent men in jail. Everybody's so passionate about Adnan's case. Get as passionate about this scumbag cop who's now walking around collecting his pension down in Texas, I think, who put 57 innocent men in prison and one woman on murder charges. All of them are innocent. 44 have been exonerated. Chicago is going to be paying, they estimate $1 billion. Why don't you check out that story? So that's what we're covering tonight. So, like, I'm all about wrongful convictions being righted. And, it's just like, come and check it out tonight. I'm not sure who it's either going to be one of the exonerees or it's going to be one of the family members or one of the persons that put together the wrongful conviction justice group. So it's going to be a good guest. Dorsch will be on with me 9 p.m. It's bound to be great. It's bound to be interesting. And if you're really interested in justice, you should probably be there. It's one thing to talk about. It's another thing to actually do something about it. I love, like, people love to talk about justice, this and that. It's another thing to actually do something about it. So, like, and you can start by watching the lives that we've been doing about Guevara. It's probably a case that no one's ever heard of. And this guy, actually 57 cases you've probably never heard of innocent men that spent 10, 20, some died in prison from this dirty cop who was framing all his people up. So check it out tonight, 9 p.m. All right, you guys, thank you so much. Thank you for your generosity. I adore you. Thank you to all the mods. I adore you. To all the beautiful humans, our fam that's always here. I love you, love you, love you all day, every day. If you haven't, please share, subscribe, like. It's how we get out. It's how we grow the show. We want to grow the show. And we need your help. We can't do it without y'all. We really love you guys. I've been missing my wife. She's babysitting and she's just been trying to finish work. So I'm hoping that I can have her with me tomorrow. I just have so much more fun when I'm with her. And I'm sure that you guys get sick of hearing me yap for 2.5 hours. So that being said, thank you guys. I adore you because without you, I'd just be an old man talking about lots of cases. See you tomorrow. Oh, actually tonight. Oh, maybe.